Thus, White concluded that the school did not infringe on students' First Amendment rights by exercising authority over school-sponsored publications. However, this did not seem in tandem with the decision established in Tinker, which staunchly purported that, quote, "students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate," unquote. Although it was a school-sponsored publication, the Hazelwood decision seemed to put a damper on the liberating decision of the Tinker case. The other three justices, however, solidly dissented with the conceding justice's decision. Justice Brennan, who wrote the dissenting opinion, poignantly quotes the decision on the Tinker case, illustrating how the Hazelwood decision usurps the principles established in the Tinker case by being an example of what it set out to disavow. That instead of encouraging the diversity of ideas in the living reality of the Constitution, the justices in their decision taught youth to discount important principles of our government as mere platitudes. While this case established the new narrow rule for similar subsequent cases, many state courts would grant more immunity to student publications than the minimal constitutional protection established in the Hazelwood v. Kuhlmeier case. The fact that many state legislatures have granted more protection to students is a stark illustration of how Supreme Court decisions are at the same time the final say, yet not the final say. The decision reflects many other cases in that it establishes a rule on terms that are relatively vague. This issue will likely make its way to the Supreme Court again, and perhaps a more liberal, clarified stance on the issue will replace the vague and restrictive rule on the student press.